Roberts.
Thank you very much. You may remember that before the short adjournment I was addressing your lordships and ladyship on why it is that we say that some significant part of the damage was sustained in England. And I was on my first point, and I was dealing with the June meeting and explaining, I hope, that something significant happened during that meeting, which is that we changed our security position from a position where we had said in the reliance letter that we would have possession of bills, but essentially no more, to a position where, under the MOD, we were given a formal pledge of the bill so that we could deal in the goods that were the subject of the bill in the event of default. And so in exchange for this formalisation of the security, agreed in principle at the June meeting, we entered into the MOD and afforded more time to TMT to pay. And paragraphs 33 and 34 of our particulars explain precisely that. So the trigger, or the genesis for entering into the MOD, is the June meeting. And it's inherent in the nature of the agreement in principle in June that Mr. Gupta was presenting to us that the bill could in fact constitute good security. And it could only constitute good security if the matters in paragraph 35 of our particulars were true. Hence why we say the second representation, and indeed all of the representations, were made expressly or impliedly. Second reason, the agreement in principle to change our security position in exchange for an extension to pay occurred in England. The inducement, which causes us to enter into the MOD, occurs in England. The forbearance that comes with it takes place in England. And there are at least two sub-points here. England would have been where Sucden was entitled to take action to recover the debt by issuing a claim sooner, and it decided not to take that step in England by way of forbearance. So if our shows in action, apropos the debt, was damaged, it was damaged in England. And let's not forget that the test is damage was sustained or will be sustained in the jurisdiction.
I mean, those words are in there to allow for quia timid relief in tort cases. You brought a completed cause of action for tort, you needed damage to complete that cause of action at the date of your claim form, didn't you?
Yes, accept that. And we say we did. And we can see on the face of the MOD itself, which if you're minded to turn up but you don't need to, is page 118 of the core bundle, that Sucden instructed its solicitors, McFarlane's, in London on Cursitor Street, around the corner, to prepare the draft of the MOD, which becomes the final MOD on page 118 of the core bundle, and you'll see McFarlane's address at the bottom. And then the MOD was signed by Sucden in Kent. See page 136 of the core bundle. That is the crystallising act of entering into the MOD. It takes place in England. And of course, although it doesn't strictly matter, both the MOD and the scheduled pledge of the bill in Schedule 2 of the MOD are expressly governed by English law with English exclusive jurisdiction. And so the second point, to sum up, is that both the inducement and the consequences of that inducement are felt here in England by Sucden. And third and final point, before I turn to my learned friend's arguments, is we know from the relevant text that it doesn't matter whether any other harmful effect was suffered in any other jurisdiction, so long as some significant part of the damage occurred in England, which we say it plainly did.
So just help me. So this appears to be aimed at an argument that the signing of the MOD or the entry into the MOD was loss. Have I understood it correct?
The argument is that the harm is being induced to enter into the MOD on the strength of the second representation made in England. I'm sorry if that wasn't clear, my lord. It's another way to characterise the harm.
Can you keep your voice up, Mr. Robinson?
I'm so sorry, my lord.
It's another what?
It's another way to characterise the harm.
Yeah.
I'm sorry, my lord. So turning now to deal with my learned friend's arguments and those of his predecessor, we have what I might call the contingent loss point. And it's put in a number of different ways. Let me just give you the references. So Miss O'Reilly's original skeleton, I believe the PTA skeleton, paragraph 58, page 28 of the core bundle. And then same skeleton, paragraph 63, page 29. And then Mr. Trotter's supplemental skeleton, paragraph 56, page 152 core. All of the points that are made in those passages essentially amount to the same argument, which is no loss has been suffered yet, or loss would only have been suffered when Sucden tried to effect the enforcement of a judgment obtained in England, and that's why I call it the contingent loss point. Now, there are multiple answers to this, one of which I've already given, and is our primary case, which is that the representation, the second representation, was made at a meeting in London. There is another reason why the argument doesn't work. At the time of applying for permission to serve out against Mr. Gupta, the relevant inquiry, as we know, is whether damage was sustained or will be sustained within the jurisdiction. The damage pleaded is our inability to recover sums due from TMT by reason of having been induced by Mr. Gupta to forbear in taking steps to enforce our rights earlier, and therefore letting a window of time pass during which TMT at least appears to have had some assets. And incidentally, although this doesn't really matter, incidentally, there is evidence that there were assets in England. Why do I say that? Well, Mr. Charlton, in his 9th witness statement, paragraph 15, page 226 of the supplemental bundle, refers to information in the public domain which show that a total of over 95 million US dollars were paid by Trafigura into a Barclays bank account held in London by TMT between the 8th of February 2022 and the 5th of July 2022. Page 226, supplemental bundle. So I'll come on to Mr. Trotter's Switzerland argument in a moment, but I would just invite you, please, to remember that we are not talking or assuming that TMT at the relevant time only had assets in Switzerland. That, I think, is an implied assertion in Mr. Trotter's oral submissions, but it is not fact. So the relevant question at the application stage was whether the damage of not being able to recover the debt, etc., from TMT was sustained or will be sustained in England. Now, Mr. Trotter positively avers on this appeal that TMT's defence to the debt claim was always, his word, hopeless. Paragraph 104, supplemental skeleton, page 162 of the call. So on my learned friend's case, TMT was always going to owe my client a judgment debt in this jurisdiction, because when permission was sought to serve Mr. Gupta out of the jurisdiction, Sucden had already issued these proceedings in England, and TMT was, according to my learned friend, always going to be found to owe us the money. Whether at a summary judgment stage or at a full trial stage, doesn't matter. It was always going to owe us a judgment debt, as regards at least the margin call. And of course, Mr. Trotter is right in the sense that we did in fact obtain summary judgment against TMT for the debt and have that judgment debt in hand. The Lacatamia case, we'll go there in a second, establishes that a judgment for a debt in England that goes unpaid constitutes damage that occurs in England. Authorities Bundle, page 1039. So paragraph 848, it said, I consider that the principles identified in Pan-Oceanic and Dolphin Maritime and the passages I have highlighted above are apposite in the present case and support Lacatamia's submission that the damage occurred in England where the judgment debt should have been but was not paid.
But I mean, that's a case in which the two causes of action advanced were the Marex tort or an unlawful means conspiracy. The unlawful means being breach of freezing injunctions whose purpose was to preserve assets so that if a judgment was obtained, they could be enforced against them.
I accept entirely.
One's got to view the what constitutes loss and where in that context. I think, and equally, if you look at the alternative way of what's the protected interest of a judgment creditor faced with the Marex tort, it's their right in the judgment. So, I mean, for myself, I don't have a great deal of difficulty with saying that that is interfered with in the place where the judgment is entered, but I wonder how scalable that argument is to other torts.
I accept entirely that the findings in the context of an unlawful means conspiracy, and just to make your Lordship's point good, your Lordship will see it's page 1034 that the heading is Monaco conspiracy. I accept that entirely. And it's a conspiracy to evade the judgment. But the relevant issue is where the damage was suffered, where you have a non-payment of a judgment debt. And all that I am relying on, paragraph 8484, is the proposition that a judgment debt that is due in England but goes unpaid is a damage suffered in England. And the reason I say that is relevant on this particular argument is that my learned friend's positive case on this appeal is that TMT's defence of the debt claim was always hopeless. And it's simply a submission. But if my learned friend wants to take that stark position, it may work against him.
I suspect his response is there's a difference between when you do have a judgment and when you don't, and you didn't have one at the date of service out, but you had a debt.
Yes, and I accept I accept entirely we didn't have a judgment debt in hand at the time. I'm relying on the damage will be sustained language of the gateway for this particular argument. What we say, and as I say, this is only one of a number of points that we have on this particular issue, is that when the application for permission to serve out against Mr. Gupta was made, Sucden fell within the words damage will be sustained within the jurisdiction, because there was a good arguable case that Mr. Gupta's inducement was going to result in a situation.
But that brings me back to my earlier question of can you rely upon the will be sustained wording when your claim is not for quia timid relief to prevent a tort, but you claim the tort has already occurred, and that's the cause of action which you're seeking permission to serve out?
Well, we would say, by reference to the language of the gateway, we can make that argument by analogy with the finding in Lecatamia, but recognising how your Lordship is looking at the point at the moment, and given that I don't need to articulate my case precisely in this way in order to get through the gateway, I'm going to move on from this particular part of the language of 9a. The real nub of the case against me is Mr. Trotter says that our shows in action was situated in Switzerland, because that's where we would have had to enforce any judgment debt against TMT. And he says the jurisdiction clause in our favour doesn't change that. And we say respectfully that's a bad point. It's common ground that we had a contractual right to enforce both under the facility agreement, clause 16.3, and the MOD, clause 26.1.3. The facility agreement says that TMT agrees irrevocably that if Sucden chooses to sue in England, TMT cannot contest that. That's clause 16.3b. And the MOD mirrors that in 26.1.1 and 1.2. So if Sucden elected to sue in England as of right, it was expressly agreed that TMT couldn't object. And so it doesn't matter that Sucden may have been allowed to sue elsewhere. The moment it chose to sue in England, which it had already done by the time the application to serve out on Mr. Gupta came to be considered, the English courts were seized of the claim. But once we issue the claim against TMT, we are prosecuting our shows in action against TMT in this jurisdiction, which of course, in the case of the debt, we pursued to a summary judgment. But even for the expenses claim, that too is a shows in action, which we are contractually entitled to pursue here in England under clause 12.1 of the MOD, and that is common ground. My learned friend accepts that at 70 to 71 of his supplemental skeleton, page 154 of the core. And I think what is happening is my learned friend may be conflating the shows in action that we are entitled to pursue here in England and the actual question of enforcing the product of the prosecution of that shows in action, which is a judgment debt. And my learned friend is focusing on steps that we might have had to take in Switzerland or some other jurisdiction to give effect to a judgment debt. But his shows in action point works against him because the locus of the shows of action that we have, whether it's for the debt, expenses, or even the tortious claim, is England, because that's what the MOD says that we can do. We can sue in England, apropos all of the causes of action.
Where was the debt payable?
London.
Why do you need more than that?
I don't. That's one of many points that I make.
Because you must have had a cause of action in tort before you issued the claim form here, one imagines, or else you wouldn't have had one.
Exactly. Exactly. Well, I apologise if I'm somewhat labouring things. My learned friend accepted, I think, orally that damage would have been in England if TMT or Mr. Gupta had acted to remove TMT's assets from England, which could have satisfied the debt. He says our case is materially different. Now, as a matter of common sense, there is no material difference at all. We're talking about the ability to get debt in simple terms. There's also another slight oddity about the position that my learned friend is taking orally, which is, on his argument, the correct jurisdiction of our claims is wherever TMT has assets. Now, as I said a moment ago, the implied assertion is that that could only be in Switzerland, but of course we have evidence that at a point in time, albeit in 2022, but relevantly in 2022 for our purposes, there were assets in England. Now, we don't know what's happened to those assets because TMT doesn't want to tell us. Didn't want to tell the court in the Trafigura claim that was resolved earlier this year. But there is something odd about a submission from a learned friend, that it's essentially wherever TMT might have assets anywhere in the world.
As and when they move them about.
Correct. So what is one to do in response to that? Ms. O'Brien-O'Reilly, I'm now just going through each of the points against me. Ms. O'Brien-O'Reilly has said in writing that our claim is for a loss of a chance. And she said on our case, we would have taken enforcement action and suffered the loss by May 2022, which she says is before the June misrepresentation made by Mr. Gupta. See paragraph 67 of the permission to appeal skeleton core, page 30. And she sets this up as if to suggest that we have some sort of fatal causation problem. And it's a very bad point. As we've explained in our appeal skeleton, paragraph 28, core 68, our pleaded case is that but for the inducement, we would have taken steps, I'm quoting, taken steps to enforce that debt in or around May 2022 and would likely have recovered that debt from TMT already. And the particulars are dated 10th of August 2023 and they were filed and served at the same time as the claim form. So 2 points. The phrase in or around May 2022 is more than capable of including June as the very next month, and therefore incorporating the June representations. Even if that is wrong, the phrase taken steps to enforce does not necessarily mean issued a claim. It could mean all sorts of things, such as issuing a default notice, starting pre-action correspondence, or perhaps seeking a Norwich Pharmacal or a freezing injunction, etc., etc. This is not a plea, as Ms. O'Brien-O'Reilly appeared to believe it was, that but for the inducement we would have received the debt back in our bank account in May. We would have begun enforcement steps.
At this point, my failure to use technology has exposed me to my pen running out of ink. If anyone has a disposable, they might then.
I've got
Could I?
To avoid any.
I don't have one, I'm afraid.
I know, master of the rolls, but I've got to take my Lady Justice Kings to avoid any Bangalore principle.
I don't use any technology, but I'm neurotic about my pens running out.
Actually, I've got a box of them in fact. I lied.
I feel suitably humbled. My apologies for the interruption.
No, not at all. The conclusion I was reaching on this particular argument from Ms. O'Brien-O'Reilly was that there is no necessary causation problem in our case at all, And let us not forget that Mr. Gupta's own evidence, which I have taken your lordships and ladyship to, is that at the June meeting, my client, quote, continued to demand immediate payment of margin calls, close quote. So were it not for what Mr. Gupta said or didn't say at the June meeting, my client would have done precisely what it pleased it would have done here in England. Now, there's then an argument that Sucden suffered the harmful effects when it took possession of the goods in Shanghai and realised that they were bad security. This is Ms. O'Brien O'Reilly, paragraph 66, core page 30. The tortious inducement that we plead has already happened well before this, in June 2022. And the realisation that the bad security you were induced to accept is not the harmful effect. The harmful effect is being induced to accept the bad security. It doesn't matter that you discover that harmful effect later on. The only other point on deceit is that both Ms. O'Brien O'Reilly and Mr. Trotter have characterised our case as simply being that we would have received the debt back into our bank accounts in England. Now, that is our case, but it's not everything that we say. And in any event, Mr. Trotter, I think, seems to accept in his supplemental skeleton that where the claim is for non-receipt of money, the damage occurs in the place that money would have been received, paragraph 52, core 151. So we seem to be ad idem on that. Now, Mr. Trotter says this rule only applies in the context of the tort of inducement and not any other tort. He doesn't, with respect to him, say why, other than, quote, it's a different category of claim. That's the
I think
language
it also accepts deliberate disablement by asset stripping.
Yes, so that was a point I made slightly earlier. Yes, absolutely right, my lord. Now, the CBD case has been referred to in my learned friend's skeleton. It's not in the authorities bundle. I think I was sent a copy of it by my learned friend over lunch, but I must confess I haven't spent the minutes I had upon receipt to look at it. But I simply want to submit that there's no good rationale for splitting up the tort of inducement from other torts, and no case has actually said that there is. So we do rely on the Dolphin case, and we do rely on Pan-Oceanic for the reasons we set out in our written submissions. That brings me on to conspiracy. So I'm still within the tort gateway, I'm still within 9A, I'm still making submissions to you about damage in the jurisdiction, but we're just looking at another tortious cause of action. It's received fairly little attention in the written submissions, and indeed the oral submissions this morning. The conspiracy claim runs as follows. We say that TMT and Minecraft were Mr. Gupta companies, paragraph 5 of the particulars, core 98, and we rely inter alia on the fact that Trafigura successfully sued Mr. Gupta, TMT and Minecraft in January this year, or I should say in a reported judgment from January this year, to be more precise. And Minecraft was, as we pleaded, treated by the court in that judgment as a Mr. Gupta company, paragraph 335. The finding is that Minecraft acted, quote, as a front for Mr. Gupta, close quote. For your reference, the citation is 2026 EWHC 159, And I can either hand up a hard copy if you'd like to see it now, or send you a soft copy now, or send you a soft copy after the hearing.
This is not being relied upon as authority for a legal proposition.
No, it is not.
This is an attempt to adduce evidence of fact, presumably, from the findings Mr. Justice saying you made.
I don't need the judgment to make the submission that there's a good arguable case that TMT and Minecraft are Mr. Gupta companies. I am noting, because it would be remiss of me not to, that there is a judgment in this jurisdiction 6 months ago that says in terms, Minecraft is a Mr. Gupta company. Our pleaded case is that Minecraft was the party that supplied the bill of lading, paragraph 51, core page 114. And the pleaded argument is that TMT, Mr. Gupta and Minecraft conspired and combined together to defraud Sucden by lawful or unlawful means to prevent Sucden from taking steps to enforce the sums due to it. Paragraph 52.2, core 115. And we say the conspiracy was executed by the matters pleaded in 52.3.
Is the unlawful means the deceit?
Yes. And I think I can see...
Trying to work out whether this
Right.
really changes the
Yes.
analysis.
I know why your lordship asked the question. The punchline that I'm going to get to is that the pleaded case is that the conspirators combined together on an unknown date in the March to August window to take steps to cause Sucden to forbear or delay in taking enforcement action. The period over which we say the conspiracy was effected is slightly broader than perhaps the deceit claim. But your lordship is right that in terms of what it caused Sucden to do, we get to inducement. So we say we have a good arguable case based on our pleading in 52.2 that conspiratorial acts inducing us to enter into the MOD and forbear, the former part of that sentence being relevant to 9b, the latter part of that sentence being relevant to 9a, took place in England. Now, perhaps I could deal with Gateway 9C, claim governed by English law, and Article 4, because as I mentioned at the beginning, there is a slight overlap. We relied on Article 4.1, and indeed Article 4.3, which I'll come on to in a moment, in our skeleton argument before Mr. Justice Knowles. It's paragraph 28.2, supplemental bundle 259. And just to orient your lordships and ladyship, Ms. O'Brien O'Reilly said nothing about Article 4.1 in her skeleton below, or, I believe, at the hearing. But Mr. Trotter deals with it in his skeleton argument. I don't think my learned friend and I are at odds in terms of the legal test and the subtle differences between 4.1 and 9a. Under 9a, the damage means direct or indirect harm. It doesn't mean a completed tort or a completed cause of action. See Brownlee 2, paragraph 81, for your reference, page 1125 of the authorities bundle. Whereas by contrast, Article 4.1 is looking for only direct harmful consequences. And then the only other difference between the two tests is, as I've said, 9a is looking at some significant part of the damage, whereas Article 4.1 is a more unitary test. That's looking for a single place.
Just by way of practical illustration, if you're hit by a car in Spain and you come back to this jurisdiction where you live at the end of your not so happy holiday and suffer pain, suffering loss of immunity, the Supreme Court 4 to 1 held that for 9A purposes you have suffered loss in the jurisdiction. But no one, I think, would suggest that the place you went to recuperate would change the applicable law of the tort, which would be Spanish law where the direct injury was sustained.
Agreed. Agreed. For the purposes of 4.1, we say that the element of damage closest in causal proximity, I'm quoting from the AMT case when I say that, paragraph 34 sub 5, combined authorities, page 485. We would say the element of damage closest in causal proximity to the harmful event is the inducement, whether by deceit or conspiracy, to cause us to forbear trying to get the debt back, accepting the bill of lading as security and doing so under the rubric of the MOD. And we say that is all tied or tieable to the June 22 meeting, where Mr. Gupta finally stops us from demanding payment of the debt immediately. I'm referring to his own evidence there, by fobbing us off with the MOD and, of course, the bill. Now, other than that, I've nothing to add to my submissions about where damage was suffered, save for this point. In the Jaffe case, particularly paragraph 296, Roman numeral 5, which is page 1366 of the authorities bundle, Mrs. Justice Cockrell, as she then was, said that it may be relevant, sometimes, to ask what would have been the position if the tort hadn't taken place. We say we would have taken enforcement steps earlier and obtained judgment against TMT at a time where TMT had assets in England. And I've taken your lordships and ladyship to the evidence in that regard. So we would have obtained judgment in England, and we have a good arguable case we could and would have enforced against TMT's assets in England but for the tort. So we respectfully say that that overwhelmingly points in favour of satisfaction of Article 4.1 for the purposes of the 9C gateway. Now, given that I'm dealing with Gateway 9C and Rome 2, let me deal with Article 4 sub 3. Even if I'm wrong about 4.1 and the damage was suffered in China, according to Ms. O'Brien O'Reilly.
Is this in the respondent's notice?
9C is in the respondent's
4.3.
notice. Yes, well, 9C takes you to Article 4 of the Rome 2 Convention. We cited Article 4.1 and Article 4.3 below. We've referred to Article 4.1 and Article 4.3 in our appeal skeleton. I'm about to come on to the references. I assume that what your lordship is alluding to is the issue of whether we can make submissions in Article 4.3 at all, and we say we can. It's not a new point. Ground 3.2, which is at Core 58, refers to Gateway 9C, which we argued in front of Mr. Justice Knowles on both 4.1 and 4.3. Mr. Trotter recognises that at least Gateway 9C was before Mr. Justice Knowles, at paragraph 4 of my learned friend's skeleton. Gateway 9C necessarily engages consideration of Article 4 of Rome 2, not just Article 4.1 or 4.2 or 4.3. Article 4.1 and 4.3 also cannot be separated because sub 3 is the safety valve as regards the application of 4.1. It's an express carve-out. So we can't artificially divorce particular sub-paragraphs.
Well, people frequently do. It just depends the scope of the argument you wish to run on applicable law. I think for my purpose, I'm just keen to understand, you're saying Mr. Trotter should have anticipated a 4.3 argument on the appeal. If that's right, that's fine. But obviously we haven't had submissions from him on it, I think, in the course of his submission.
I think he did anticipate I was going to make submissions on it, because he said this morning that he was going to take the position that I wasn't entitled to make any arguments on 4.3. He knows full well that I was going to, because it's, as I say, in my skeleton below and in my skeleton for the appeal. And there's no jurisdictional problem if you're relying on passages of Article 4 in circumstances where I've got permission to make submissions on 9C, and that necessarily requires one to look at Article 4. And I say look at Article 4 in its entirety. And if it assists, Mr. Charlton, in his evidence before Mr. Justice Knowles, said in terms that there was no other country other than England that was more manifestly closely connected to the dispute. And he said that in paragraph 30 of his witness statement that you will find at page 231 of the supplemental bundle. Now, Mr. Charlton, and I want to be very frank about this, made that point in the context of identifying the most appropriate forum, and the specific factor that he is considering in that part of his statement is governing law.
Help me where it is in the appeal, in your skeleton for the appeal. I'm sure I haven't necessarily picked that up, for which apologies.
Only one moment, Lord. It's paragraph 34.
I wondered what you were going to say.
So it's 4, page 69.
And is that the only reference to Article 4.3
in this skeleton? Yes, my lord.
Because there's a lot of law on this.
Yes.
Including that the high threshold before the presumptive rule in Article 4.1 is displaced. Case law considering the relevance of choice of law clauses where there's a contract between the tortfeasor and someone else relevant to the claim, none of which is referred to in this paragraph.
The only context in which this is going to arise is if your lordships and ladyship are not with me on 9A and Article 4.1 of 9C.
Well, that's not really the point. The point is it open to you? And is it fully argued?
Well, I don't want to strain this. If your lordships and ladyship are against me as to whether I can argue this, I will just shut up and move on. Or I can make my submissions on 4.3, and which will probably take a few minutes.
34 advances no 4.3 argument, does it? It says 4.1 applies unless the 4.3 default applies, and then it explains why you say 4.1 applies because the harm was suffered in England.
Yes, but it does.
Read fairly, Mr. Robinson, that's not a 4.3 argument.
Well, I shall move on. That brings me to 9B, damage resulting from an act committed in England. There is a mercifully pithy summary of the test in the White Book. I don't know if your lordships and ladyship have a copy of the White Book. If not, we can hand up hard copies of the relevant passage.
Which page do you want?
355, please.
I welcome a hard copy.
Thank you. So we are in section 6HJ.23 of the commentary, and I want to pick up the final two lines of page 355. And that says, this is talking about 9B, the requirement obliges the court to look at the tort alleged in a common sense way and to ask whether damage has resulted from substantial and efficacious acts committed within the jurisdiction, regardless of whether or not such acts have been committed elsewhere. The question is where in substance the cause of action arises. If the court finds that the tort has in substance been committed in this country, the fact that some of the relevant events have happened abroad is irrelevant for these purposes. This approach was applied in Manic. The Court of Appeal held that misrepresentations made at a meeting in London...
Where are you, please? Which page?
I'm so sorry, my lord. I started in the final 2 lines of page 355.
Yeah, no, I've got a 25 version.
Oh, I'm so sorry. We can hand up a hard copy if that would help.
Yeah, you better. Can we just make sure that we produce electronic copies of documents we want to refer to? It's not difficult.
I'm sorry, my lord.
It's far too small. I can't read it.
I see.
Which page? 355.
Yes, at the bottom of
Metal
355,
and rust rock.
2 lines up from the bottom is where I began, and we are now on 356 towards the top. And if I just pick up what I was reading out, this approach was applied in Manic. The Court of Appeal held that misrepresentations made at a meeting in London were substantial and efficacious acts committed within the jurisdiction, regardless of whether more important events had occurred elsewhere. Similarly, the making of a conspiratorial agreement in England has been found to amount to substantial and efficacious acts sufficient to bring the claim within this gateway. Our submission is that the pleaded misrepresentations and or the execution of the conspiracy at the June meeting is enough for our purposes. If I take deceit first, now obviously what was said by Mr. Gupta at the June meeting is disputed and a matter for trial. What is not disputed is that the meeting took place. And after this meeting, the parties did go on to negotiate and agree the MOD. That is admitted at paragraph 54 of TMT's defence, signed by Mr. Gupta, page 142 of the supplemental bundle. And we know that that meeting, as I say, was in Marylebone according to his evidence, page 172 of the supplemental bundle. We say we've a good arguable case that one or more representations were made at this meeting as pleaded, and so some substantial and efficacious act plainly took place in London as regards the deceit claim as a matter of common sense. Mr. Trotter has said in print, in paragraph 42, core bundle 148, in the 4th line, he says this, quote, "It is not even alleged that Mr. Gupta said anything about the contents of the containers or gave the impression that he knew anything more than C or could verify its accuracy." We say that's not a good point. The second sentence of paragraph 33 of our pleading refers in terms to Mr. Gupta during the London meeting, confirming that TMT would agree to formalise further the agreement contained in or evidenced by the reliance letter by way of a pledge of the bill of lading. And B/L, bill of lading, is defined in our particulars at paragraph 27. And then the rest of paragraph 33 says as security for the debt. Now, I've been to the reliance letter. I don't need to go there again. If one looks at paragraphs 33 through to 36, it is respectfully obvious what our claim is. It's that Mr. Gupta impliedly or expressly made a representation of the London meeting that induced us to enter into the MOD. And if there were any confusion about that, paragraphs 24.1 to 24.3 of the reply, supplemental bundle 155, puts that beyond doubt, if there was any doubt, as does paragraph 47 of the particulars. So respectfully to my learned friend, we do allege that something was said, or importantly not said, about the contents of the containers apropos the bill of lading. The next argument is that nothing substantial or efficacious happened at the June meeting. That's paragraph 41 of my learned friend's skeleton, page 148 of the core. Quote, by the time of the London meeting, C had already collected the bill of lading and already agreed to forbear. ... It has no pleaded case that despite those events, the London meeting caused loss. And again, respectfully, I'm afraid that does ignore our pleadings. Specifically, paragraphs 33 to 36 of the particulars, paragraph 47 of the particulars, and paragraph 24 of the reply. And if it matters, paragraph 24.3 of the reply positively pleads reliance on an omission or half-truth. And we say this is enough for our purposes. The error in the submission from my learned friend and his predecessor is the belief that the sole pleaded case is that the die was cast in terms of us forbearing by March 2022. That's the problem.
You have said that several times.
I'm so sorry.
No, I mean...
It appears a number of times. And what I don't want to do by the end of these submissions is leave your lordships and ladyship wondering why I haven't dealt with a particular point. And the difficulty in a sense is that I keep coming back to the same point because it's the answer to all of the all of the case against me. I'm sorry about that. I'll try and move on a bit more swiftly.
Well, if it is the answer, you know, one can be short about it.
Thank you. The simple point I want to make is that we kept getting continuous representations, if you look at the pleading, and we kept forbearing in response to them. It's a continuing and developing picture. It's not just one and done. It's not just one misrepresentation and we forbeared forevermore. And your lordships and ladyships saw when I took you to the reliance letter that there's no agreed deadline for payment in the reliance letter. That just leaves when TMT is going to pay open. It's only when we get to the MOD that there's an actual deadline that's afforded by us in exchange for the bad security. So we say that the argument made on the other side that the June meeting wasn't causative of any loss on our case is just a bad point. That brings us to conspiracy, and I can get to the heart of the point if I simply say that in our case the crescendo of the conspiracy effected against us is the June meeting. Because, as I say, that's the point at which Mr. Gupta manages to shut my client up, my client who keeps demanding payment, in exchange for a fixed date for payment, breach of which will result in an event of default. And we say that's a significant, substantial, or efficacious act by which the conspiracy was effected. Mr. Trotter then says, I think as a last resort really, that we can't rely on 9b at all as a gateway. That's paragraph 29 and following of his skeleton core, page 145. 2 points that my learned friend makes. He says, well, Mr. Gupta would have adduced more evidence. And his second point is that the hearing below would have ran differently than it did. Well, on the evidence point, Mr. Trotter says in his skeleton that we needed, before Mr. Justice Knowles, to adduce evidence that we had a good arguable case that a tortious act was committed at the London meeting, And your lordships and ladyship may have seen reference in the written submissions to the Fowler and Barstow case, relied on by my learned friend. And he relies on that to allege that Sucden had to establish an actionable act in England. Just a note, in case it matters for your judgment, reliance on Fowler is slightly odd, because in that case, the reason why the court found that there had been no tortious act and set aside permission to serve out is because the plaintiff's own position in evidence appeared to be consistent with what the defendant said, which is that the misrepresentation hadn't happened in England. See page 85 of the authorities bundle. It's completely unlike our case, where it's common ground the June meeting took place but disputed what was said and done. So taking a step back on the evidence point, it's not clear to us what evidence my learned friend says Mr. Gupta could or would have adduced that's relevant to the question of whether the June meeting was a substantial and efficacious act for the purposes either of our deceit or conspiracy claim, particularly in circumstances where our pleading, as is common in fraud cases, is put on a necessarily broad footing, where we refer inter alia to omissions or half-truths committed during the June meeting. Well, how does my learned friend suppose that Mr. Gupta is going to meet in evidence an allegation that he committed fraud by reference to what he didn't say but was under a duty to say? It's difficult to understand what that evidence would be. As for the hearing below being conducted differently, the suggestion wasn't really developed orally beyond the submission that there would have been different evidence. I'm not sure if it's really an independent point beyond that. If it is, I'm not sure what the point is.
How long did the hearing last for Mr. Justice Knowles?
A day.
A day?
Yeah. That brings me on to Anchor Gateway, where I'm just going to have to apologise before I begin because there's just a lot of ground to cover. But
Well, we won't stop you, but take it reasonably, briskly if you can.
we are ad idem as to the need to do that. I will do my very best. I'd like to address, please, the words has been or will be served first. And I just want to set out what the argument against me is so far as I understand it. I don't mean that pejoratively, I mean that sincerely. CPR 611 was wrongly relied on by Sucden, is the allegation, when we served TMT, because the claim made was not solely in respect of the MOD contract, which gave Sucden the right to serve process. That's point one. The next point is that if service against TMT was defective, the Anchor Gateway can't be relied on to bring Mr. Gupta into the jurisdiction. This is all Ms. O'Brien-O'Reilly, original skeleton, 37 to 38 and 48. Supplemental bundle 241 to 243. Now, before Mr. Justice Knowles, Ms. O'Brien-O'Reilly said nothing about the words, all will be served in the gateway. She focused entirely on has been served. We referred Mr. Justice Knowles to CPR 633-2BB in our skeleton at page 266 of the supplemental bundle, where at paragraph 40 we said even if what we've said about CPR 611 is wrong, we came within the or will be served language pursuant to CPR 633-2BB. To which I think the argument against me is twofold. First, you don't come within the or will be served wording because either you didn't or wouldn't have served a notice 510 under CPR 634. And then second, an argument that is probably just best read out. This is paragraph 33 of Ms. O'Brien-O'Reilly, core 22, fourth line. Quote, further, as D1 submitted to the jurisdiction, it cannot be said that D1 will be served in the future in accordance with the CPR because the question of service is over between C and D1. Now, Mr. Trotter then expands on those points. There are only two new points on analysis. The first is that he says, so far as CPR 611 is concerned, the claim for the 100,000 plus of expenses doesn't appear in the claim form, he says. And so he says, you can't read the claim form and the particulars together to remedy that defect.
Claim form says particulars of claim are attached, doesn't it?
They don't only just say that. If you look at the numerical claims, there's a difference between the one at the beginning and the one at the end, and the reason is the expenses.
Well,
I'm actually going to come on to it.
right, I would, at the moment, rather doubt this is going to be the key issue in the appeal, as in terms of...
Well, if that's a view shared across the bench,
Well,
I can certainly leave it. But,
ought to speak for now, but it
Well-
would seem an unlikely point on which the...
well, it seems very unlikely to me, but we are where we are. And then the second point that my learned friend develops is he says, so far as CPR 633-2BB is concerned, the time for service of the claim form expired by the time TMT was served. Okay, structure. Let me deal with 633 first. If I'm right on 633, 611 is a sort of almost interesting but irrelevant debate. We say that if at the time of issuing the claim form we were able to serve out of the jurisdiction on TMT without the court's permission, the language of all will be served in the gateway is satisfied, and that's the end of the inquiry. Now, why do I say at the time the claim form was issued? Well, my learned friend's predecessor had accepted that that is the relevant point in time for the inquiry by reference to the ID and LU case. And just to give your lordships and ladyship the reference, its original skeleton argument before Mr. Justice Knowles, paragraphs 45 to 46, page 243 of the supplemental bundle. And what was set out there is paragraph 49 of His Honour Judge Pelling KC's judgment in IDLU, where he said, quote, at least at the time the claim form was issued, the claimant must be able to serve the anchor defendant either within the jurisdiction or out of the jurisdiction in accordance with one of the provisions of para 3.1 of 6b, other than Gateway 3, or as permitted out of the jurisdiction without permission.
Why isn't the right time when the judge makes the order granting permission to serve out on the necessary or proper part?
Well, on our case, it wouldn't matter whether it's at the time the claim form is served or at that later point.
But in terms, as a matter
As a
of
matter
principle,
of principle, it does strike me as rather odd to focus on the point at which the claim form is issued in circumstances where an application for permission is required apropos the...
when the judge is applying it anyway, when he's asked to make the order to serve out. So.
Yeah. But I wouldn't rally against that, my lord, at all, because as I say, it doesn't matter. The reason for me making the point is simply that I had thought that it was common ground until Mr. Trotter alighted on it's really the point at which permission is applied for, but I'm perfectly happy and for the rest of my submissions to assume that that's the relevant point in time. Perhaps I could just set out why we say we're in were able, in fact, to serve out under 6332BB, clause 26.1 of the MOD at core 132 26.1.1, English courts have exclusive jurisdiction to settle, quote, any dispute arising out of or in connection with any transaction document. Worth also pointing out 26.1.2, TMT agreed it wouldn't argue that English courts were not the most appropriate forum. Transaction document is defined page 121. It means, quote, this memorandum, comma, each deed of confirmation and any other document designated as a transaction document by the debtor and the creditor. So 26.1.1 means the court has exclusive jurisdiction in respect of any dispute arising out of or in connection with both the MOD itself and the bill of lading, because the definition of deed of confirmation at page 120 is, quote, a deed of confirmation executed by the debtor in substantially the same form set out in Schedule 2, ... or any other form agreed between the parties. Schedule 2 is at page 134. That is the format of the actual deed of pledge of the bill of lading. If it matters, the facility agreement is supplemental bundle page 18. And at clause 16.3 of the facility agreement, it is said, under the heading jurisdiction, quote, subject to applicable regulations, which are defined over leaf but don't matter for present purposes. Each of the parties irrevocably, A, agrees, that the courts of England shall have jurisdiction to settle any suit, action or other proceeding relating to this agreement, and irrevocably submits the jurisdiction of such courts, and B, waives any objection it may have to the laying of venue, and agrees not to claim that such proceedings have been brought in an inconvenient forum. The upshot of all of this is that any and all disputes, whether in contract or tort, which arise out of or relate to the facility agreement or the MOD or the bill of lading, are subject to English court exclusive jurisdiction. If I were to categorise our claims, they are as follows. A debt claim and a damages claim for the 6.6 million under the facility agreement. See paragraph 23 of the particulars and para 1 of the prayer. There's then a debt claim and a damages claim for the 100,000 plus expenses. Paragraph 50 of the particulars, subpara 2 of the prayer. There's then a damages claim in deceit for both the 6.6 of debt and the expenses. And there's then a damages claim for conspiracy for the 6.6 debt.
Just rolling this forward a little, I don't understand Mr. Trotter to dispute that the claims fall within one or other of the EJCs. I think he takes his stance on the absence of the certification and the fact that it was never done. Now, as to the former, if you had written to them saying we're able to serve you out of the jurisdiction without leave, will you accept service? And let's shorten this, as one would hope. Occasionally people might be willing to do. How would that work in terms of this argument on has been or will be served if it was then served in that way without ever needing to follow the 633 route, because people recognised that would be an idle requirement?
Forgive me, my lord, what am I assuming and at what point in time?
Just prior to the stage when permission to serve out is sent against the necessary or proper party, the anchor defendant says, well, I'm going to accept service within the jurisdiction because I can see you've got a right to serve without leave out of the jurisdiction if I don't. And efficiency and the overriding objection and so on, I'll just cut it short.
Admittedly, not quite our case.
No, but I'm just trying to test the proposition. Does it follow on Mr. Trotter's argument that the necessary or proper party gateway couldn't be invoked in those circumstances?
No, we can invoke it for the purposes of serving out on the third party, because
I think my lord's attempting a point in your favour.
I am, but I'm doing it ineptly.
I very much doubt that. I suspect any ineptness is mine.
The point, just to make it clear for others here, is if you can simply write and get agreement that service will be accepted,
Yes.
it makes no sense to imagine that the other defendant, who is a necessary or proper party, that the rule is completely negated by that having happened, instead of going through the laborious procedure of applying to the judge and sending it to some service process server in Switzerland or somewhere else. So
Yes, I am now logged in.
it can't possibly mean that, it might be said. Yeah?
Yes, my lord.
You would adopt that argument?
Yes, my lord.
Right. Very good. We understand it.
I think the next point from my learned friend is paragraph 33. Actually, I think I can move on from that, forgive me. Perhaps I can address the point that us having effected service on TMT out of the jurisdiction is something that we can't rely on. The only point I want to make is, obviously the relevant inquiry is whether at the time permission was sought against Mr. Gupta, we were able to serve TMT out of the jurisdiction and we simply say that we were under 633(2)(b). And we're not relying on the fact of what has happened as a sort of lad and marshal, this resolves the entire inquiry. We're simply relying on the fact that we have effected service. I don't actually think that's contested, other than my learned friend's recent application to undermine Mr. Justice Dias's order of December 2025. The point is simply that at the time that we we sought permission and obtained permission to serve out against Mr. Gupta, we were obviously able under CPR 633, and the best evidence that we were able to is the fact that we in fact did.
I mean, looked at another way, there are a variety of means of bringing the anchor defendant before the jurisdiction, as there were here. The exclusive jurisdiction clause, you could have got permission to serve out on applicable law.
Yep.
You argue you got CPR 611. I suspect a claimant bringing that claim and say, well, I intend to serve them by whichever of those works, and if one of them doesn't, I'll do it by one of the others.
Yes. Yes, and there's a hint of a suggestion in my learned friend's submissions orally and also in writing that the concept of service is sort of one and done event. You have one shot and that's it. Because my learned friend says on occasion, well, because you elected to effect service under this route, you can't rely on the or will be served language because you've decided to take a particular route and you haven't evidenced an intention to do anything else. That's how his notice 510 point materialises. He says you didn't evince an intention to serve a 510 notice under CPR 634, and it just misses the point. It's the point that you've made, my lord, which is you can continue to attempt to effect reservice as often as you like if you're permitted to do that. It's not a sort of one hope only theory of service act. The only circumstance, just so that you're all aware, the only circumstance in which it was ever suggested that TMT hadn't been properly served is during Ms. O'Brien-O'Reilly's oral arguments in front of Mr. Justice Knowles. So just so that everybody's clear about...
She raised what, 611?
Exactly, she raised 611 and 634. So the only point in time at which we had to face this argument was before Mr. Justice Knowles orally And that explains why we then did what we did, which is to ensure that there could be no silly arguments taken on this by just reserving TMT.
What did you say about 611?
Ah. Well, we say we were entitled to serve out under 611
Because?
The language of 611 was obviously satisfied because we have a claim for the debt, a claim for expenses, and a claim for claims in tort, which all fall within, forgive me, the jurisdiction clause 26 of the MOD. And all I need for my purposes for the anchor gateway is to establish that at least one of my claims was properly served out on TMT, and we say all of the debt, expenses and tort claims fall within clause 26 of the MOD, and that is why we were entitled to rely on 611.
You mean they fall within the service of suit authority granted by
Yes, yes, exactly. Exactly. So CPR 611 talks about a claim needing to be made solely in respect of the contract. We say, let's just take our expenses claim, for example. Our expenses claim is covered in the claim form. It's the product of the differential between the two figures. I mentioned this earlier. There's no ambiguity about that. My learned friend seems to suggest that I'm not entitled to argue that 611 is satisfied in respect of the expenses claim, because he says it's not a claim that's been articulated in the claim form under the MOD. And that's wrong, not just because we say see attached particulars of claim, but it's also wrong because we say in paragraph 5 of the claim form, quote, as at the date of this claim form, ... the sterling equivalent of the debt and additional charges claimed by the claimant. Which is enough for our purposes to establish, and I'm only dealing with the expenses claim at the moment, enough for us to establish that the expenses claim was a claim that we were entitled to serve out under 611, because it's a claim that falls within clause 26 of the MOD.
It falls within, what did you say?
Clause 26 of the MOD.
26.3.
Yes. 26.1.1. Any dispute arising out of or in connection with the transaction document. And we have a pleaded case at my lord.
So how does it arise out of, in connection with the transaction documents? Just spell it out for me.
So the claim for expenses is subject to a particular clause in the MOD. It's clause 12.1 at page 128. So charges, costs and expenses.
Right, okay, I get it.
Yeah, and then what we do in the particulars, my lord, is we plead reliance, express reliance on clause 12.1 at paragraph 50 of the particulars of claim. My learned friend accepts that the claim there is made solely in respect of the MOD, which is why the expenses claim is quite convenient to think about.
But there are claims you accept, are there, that are not solely made under the contract?
No, my lord. What we have is a scenario where I have 4 different types of claims.
What about the conspiracy claim?
Well, that falls within 26.1.1. Arising out of or in connection with any transaction document, and transaction document, as I've mentioned, includes this MOD. So the conspiracy claim is that we were induced to enter into the MOD. So the inducement plea, central to the conspiracy claim, is a claim we're entitled to serve out under 611. What I was about to come on to say, my lord, is we have the 4 claims, which I've articulated. All of them fall within the MOD. Now, it just so happens that they all also fall under the, or can be articulated under, the trading facility. But for 611 purposes, that doesn't matter. It doesn't matter that you can bring all 4 claims under both contracts. So long as you can bring all of your 4 claims under the contract that permits you to effect service on the process agent, 611 is satisfied.
So, I mean, just what slightly troubles me on the language is, I completely get the first part of 611. A contract contains a term providing that in the event of a claim being started in relation to the contract, the claim form may be served by a method specified in the contract. Okay. And a claim solely in respect of that contract is started. The provisions of 26.1 and 26.3 are very broad.
Yes.
And they provide, apparently, for exclusive jurisdiction and particular service in respect of claims that could be said to arise outside the contract itself.
Well, could be said to also arise.
Well, I suppose that's what I'm asking, really, because you heard the little debate between members of the bench earlier in relation to the proper meaning of a claim solely in respect of that contract.
2 points.
Yes.
Imagine you have a scenario where contract A affords you the process service provision, but your claim can only be said to arise under contract B, where you don't have the benefit of the service provision. On an ordinary reading of 611, you can't rely on the service provision in contract A to effect service of your contract B claims. And that's the context in which my learned friend relies on the case whose name I can't remember, forgive me. Our position is different. Our position is you have claims under contract A, which you are entitled to bring under contract A, and you have the benefit of a service provision. Those claims could also, if you liked, be brought under contract B, where you don't have the service provision.
I get that point. You made that point.
And
can I ask you this?
Yes.
Let's assume you're wrong, and the conspiracy claim is not in respect of the contract, but is outside the contract. I'm not prejudging it. Just assume. And it's something outside the contract, or was induced the contract to be created, or something else, and it's not properly under 611(1)(b, a claim solely in respect of that contract.
Yes.
Do you advance the argument put forward by Lord Justice Foxton that the proper construction of 611B is to construe 611B in the context of 611A as being purely so as to make sure that party autonomy is maintained? Or do you say, or don't you?
No, that's exactly what we say, Lord.
That's exactly what you say.
Yes, as a matter of proper
So
construction.
you say even if the conspiracy claim is not brought in respect of the contract,
Yes.
Those words don't meet. I mean, I'm using those words colloquially now.
Yes.
Those words are not sufficient to exclude it.
Correct.
Because it would be absurd if they were.
Deeply.
Sorry?
Deeply.
Deeply. Deeply absurd. There's no authority.
Yep.
Sorry, I didn't mean to interrupt.
No, not at all.
Conversation with your junior, but there's no authority that says one way or the Now you do need your junior.
Not that we are aware of.
No. Okay. Thank you.
And just as a reminder, and mercifully I'm reaching the end of my submission, just as a reminder, it's enough that our claim form includes a claim in respect of the MOD. It doesn't have to be all of the claims that we articulate.
I'm not sure that's right. If CPR 611 1B is doing anything at all, it's stopping you having that sort of mix and match. So if you have a claim form that includes claims that don't fall in the scope of the service authority of the agent, at the moment I struggle to see why 611 1B wouldn't knock you out. Now, if the service authority of the agent is wide enough to capture all claims of the kind in issue, that's not a problem that's going to arise.
Which it may be.
Yeah. So long as we have a claim that we are entitled to bring against the anchor, that is enough for us to rely on the anchor gateway. And I was going to make that point by reference to some commentary in the White Book.
Why would that be in doubt?
Well, I don't think it can be in doubt, but it's simply to make the point that the threshold for us here, in terms of being able to rely on the anchor gateway, is incredibly low. Because on any view, and even accounting for all of Mr. Trotter's technical arguments about what the claim form includes, the claim form includes a claim under the MOD, whether it's for the debt or it's for the expenses. So it's just taking a step back point. And I'll just give you the reference without reading it out. It's page 284 of the White Book. It's the final
2026 edition.
Yes. Page 284, final paragraph, 5th line, and it begins where the claimant is served.
Just read it.
So where the claimant has served a claim form out of the jurisdiction.
I'm so sorry, whereabouts on this?
No, don't apologise. It's page 284.
Yeah, I've got the page.
And it's the final paragraph on that page. And it's the 5th line.
Right.
And can your ladyship see a passage that begins where the claimant is served?
Sorry, so in paragraph 6.33.5. Is that right? The wrong page.
So on page 284,
284, yeah.
do you see the final paragraph before 633.5?
Yeah,
5 lines down within that,
yeah.
where the claimant has served a claim form out of the jurisdiction reliance on 633.2bb, I'll come back to that. But it contains a claim which falls outside the rule, as well as a claim which falls within it. The fact that permission should have been obtained to serve the latter does not affect service of the former. See Pantheon, and it gives the reference. Now, I accept entirely that this refers to 633.2b, but we say the general principle is that if you are entitled to serve the claim form in respect of one claim without court permission, and you do that, the claim form isn't invalidated if another claim required court permission to serve out, which I think is the effect of Mr. Trotter's argument.
Is there any equivalent in 633.2b to paragraph 611.1b? Question 1. Question 2. If you're right that 611 allows you to serve a claim which includes both claims falling within and falling without the scope of the agent's authority, what is 611.1b doing?
Point 1, the answer is no, I don't think that the two provisions are equivalent. The second, I may just want to think about for a moment, if your lordship permits.
Of course.
Yes. Yeah. we're not suggesting, and I hope I haven't implied this, that because you are able to serve one of your claims under 611 legitimately, and otherwise not able to serve your other claims under 611 because they don't fall within that rubric, we're not saying that those other claims are then automatically dragged in to the fact that you've served your one validly served claim out.
No, but you are contending that the one claim you validly have,
yes,
is
enough.
validly served in accordance with 6.11.
Yes, and enough for the purposes of the anchor gateway.
And the question is whether the permission in 611 can be met in that scenario, because it only arises where the claim is solely in respect of that contract.
Well,
is started, not served under 611, is started.
yes, but if you have three claims and one of them falls within this rubric, so it's a claim solely in respect of the contract, and therefore you're within 611 legitimately, it doesn't matter, ex hypothesi, that you may have other claims.
Well, it's a bit strange drafting, if you're right.
I mean, that might be a very good rule, because at the moment, it's not, I have to be careful, because when one says that sort of thing in front of the Master of the Rolls, you can find yourself assigned to a working committee, but you can certainly see an argument on the face of things that you should be able to serve by a contractually agreed method that which you can serve by the contractually agreed
Yes.
method, and the bits that you can't, you're left to.
Yes, well, what I'm saying
Follow
is
some
that,
other
that is a
mechanism.
potential construction of
Right.
611, which we would...
So the difficulty with that is the problem that you're effectively laying open the possibility of proceedings that are not entirely validly served existing without knowing which bits are validly served and which bits are not, which is the worst of all possible worlds, because we want to get these interlocutory skirmishes over at the beginning and then at least know you've got a set of proceedings that you can pursue. So, and just to make the point I was trying to make a little earlier, the drafting of 611 doesn't stop at B. It says where a claim solely in respect of that contract is started, the claim form may be served by the method specified. In other words, you can't serve it unless it falls within B.
validly.
That's my point.
And of course, the moment in time where this all comes real is when the party contests jurisdiction and says, well, I haven't been properly served because you weren't entitled to rely on 611, and then you have the argument.
Anyway, I think we've
Yes.
got where you're.
Well, I think where that leaves me is simply to deal or to touch on, is there a real issue that's reasonable for the court to try?
Yeah.
Which is the last, I think, limb of Mullen and Friends' points on anchor. So, just for your reference,
Well, this is the point about there's no real issue because they said there was no. They agreed.
well, there's a few points, I'm afraid. So,
Right.
paragraph 103 to 105
Yeah.
is where Mr. Trotter deals with real issue, debt, tort, expenses.
Yeah.
So at 103, you get the argument that at the time permission was granted, there was no real issue to be tried. And I think what my learned friend wants to argue is that essentially TMT had, in correspondence, said it wouldn't put up much of a fight. I think that's essentially what my learned friend says. But of course, the problem is TMT filed an acknowledgement of service that Mr. Gupta signed, saying the claim would be defended. TMT then filed a full defence authored by counsel and signed by Mr. Gupta, which contested liability on all bases. It then put in a full-throated response and defence to the summary judgment application, relying on evidence authored by Mr. Gupta. And even if all of that is wrong, Mr. Trotter respectfully is ignoring the expenses claim, the damages claim in deceit, and the damages claim in conspiracy, which are all extant claims not resolved by the summary judgment, where there is a real issue to be tried. Mr. Trotter's response at paragraph 104 is to say, in any case, the defence was hopeless. He's talking about TMT's defence. Remarkable submission, not least because Mr. Trotter doesn't actually say why.
Or which bits?
Yes. So Mr. Gupta signs the defence, page 147 of the supplemental bundle. If and to the extent Mr. Trotter is suggesting that the denial of liability in the defence is hopeless, how is it, on his case, that his own client signed a statement of truth, and how is it that Mr. McKell, original counsel, felt able to settle the pleading?
Well, I think we've got the forensic points.
Yes.
I think we just need the legal ones, really.
Forgive me. And then at paragraph 105, Mr. Trotter says there's no real issue on the expenses claim because TMT has no viable defence. Again, the expenses claim is extant. It remains ongoing. It has been the subject of a defence put in by TMT and signed by TMT. That's the end of it. And then reasonable for the court to try. The submission in 106 of my learned friend Skeleton is that the tort claims add nothing at all to the quantum of the two death claims, and so the court shouldn't try them. Not a good submission, respectfully. We are entitled to prosecute our tort claims alongside our death claims, and particularly as regards the expenses claim, in respect of which we have no judgment as things stand. And then Mr. Trotter says in paragraph 108, I don't know if he maintains this, but he says in 108 that we no doubt left our expenses claim out of the summary judgment application intentionally so that we would have a hook for the anchor gateway against Mr. Gupta. Now, he's no evidence for that, and it's wrong. All that remains is for me to thank your lordships and ladyships for bearing with me. Those are my submissions. Bear with me. No, those are my submissions.
Thank you very
Thank
much.
you.
Yes.
Thank you, my lord. I think on a large number of points, our learned friend and I have joined issue, so I'm not going to go over every point that...
You don't need to go over it all again.
No, I'll certainly try not to. What I'll try to do is to pick up points that I may not have adequately addressed in the first round.
Well, perhaps try and reply to the points he made is
No,
quite traditional.
yes, reply to the points that he makes,
Yeah.
to which I have not yet dealt with. My lord, in the context of the place of damage gateway, one of the points taken was that because Sucden went on to sue TMT in England, that means that insofar as the damage is constituted by the reduction in the shoals in action, and that too is in England, because that's where it was pursued. Our learned friend said that the memorandum of deposit was subject to an exclusive jurisdiction clause, and for that reason, independently, any damage would have occurred in England. My lords, the reason why I say that the shoals of action is situate in Switzerland is not anything to do with where the assets happen to be located. It's because that is the domicile of the debtor. And there's a distinction drawn in hardy exploration between the locus of a shoals in action pre-judgment and post-judgment. That judgment your lordships may be familiar with, but it's in the authorities bundle at tab 26. At page 723 of the hard copy. But the point that I'm interested in starts at page 753. And there's a discussion about the citus of debts by reference to quite a lot of authority. In particular, over the page at 754, at subparagraph 7, the learned deputy judge explains that the approach to determining the citus of debt will differ if the relevant debt has not yet been established by a judgment. And in paragraph A, before the relevant judgment or award establishing the right to the debt may be determined as properly recoverable only by the court of competent jurisdiction to determine whether the relevant debt is properly recoverable or has been discharged. That may well be the court of the state where the debtor resides or is domiciled, especially where that court will have jurisdiction in respect to claims against persons within its own territorial jurisdiction. And then this, unless it is excluded by agreement, such as the exclusive jurisdiction agreement between the creditor and debtor. And one can well see the good sense in that, because the starting point ordinarily is that one can sue a debtor in the place of their domicile, and one needs to locate the debt in a single place, both in the context of this judgment, which is dealing with third-party debt orders and the question of whether debts are validly discharged, but also for the purposes of applicable law or jurisdiction under the European regimes. Now, of course, if that has been excluded by agreement such that it's not possible to sue the debtor in the place of their domicile, then it's natural that the situs of the debt would be the place where the parties have agreed it must be located, which would be a single jurisdiction. But in this case, the two jurisdiction clauses on which my learned friend relies are not exclusive. They're asymmetric jurisdiction clauses, which are non-exclusive. I think that might be disputed, so I ought just to turn them up. One of them, I say, has an obvious typographical error in it. The trading facility is at S2, page 18. We've seen this jurisdiction clause a few times now. It's paragraph 16.3. And so, paragraph 16.3a, TMT agrees for our benefit that the courts shall have jurisdiction to settle any suit and so on. And paragraph B waives any objection which it may have to the proceedings being brought. But we see at the end of paragraph A, provided this shall not prevent us from bringing an action in the courts of any other jurisdiction. So Sucden, as is commonly the case when one is including jurisdiction clauses within one's own standard terms, has preserved its right to bring actions elsewhere.
But the other one at 26.1 is an exclusive jurisdiction clause.
No, that's the memorandum of deposit. So that one is at page 132 of the bundle.
2641.3, that's got a typo in it.
It does, my lady, yes. That's the point that I was
There
going
seems to be a missing note.
Yes, that's exactly the point I wish to make. Because one can see that in the very next sentence, to the extent allowed by law, the creditor may take concurrent proceedings in any number of jurisdictions. And so that ought to say the creditor shall not be prevented from taking proceedings relating to the dispute. And I submit that that's an obvious typographical error that can be remedied by construction.
Is the situs of a debt the same thing as where the creditor suffers loss by interference with the debt?
Well, it depends on the nature of the claim and the nature of the loss in a particular case. I accept that's a bit unhelpful, but in this case, where the nature of the damage being alleged is that the enforcing party was induced to forbear from taking action in relation to it, and then during that delay period, I say the diminution of the debt is impaired, meaning it's less valuable, then that is the location of the damage, because it's the value of Sucden's right, which has been impaired by the diminution of TMT's position.
I mean, absent rectification, clause 26 looks like an exclusive jurisdiction clause so far as you're concerned, or so far as TMT is concerned. Because the exception in 26.13, even if you put in a not, is about the creditor.
Well, yes, and the creditor is Sucden.
Yes.
Yes.
So it doesn't give you the opportunity to take. It doesn't give you the. It binds you.
Yes.
To use the courts of England and Wales.
No, I accept that. So if TMT was bringing an action, that would have to be brought in England.
Exactly.
But it preserves Sucden's right. So Sucden could very well have sued TMT in Switzerland.
If it had you had some money somewhere, it could do so. Yeah.
If it had chosen to do that.
Exactly.
So my point here is that the place where Sucden chose to bring its action against TMT can't be determinative of the place where loss is caused, where it could very well have chosen either place. Because otherwise it creates jurisdiction just by bringing the claim here.
Okay.
Now, relatedly, my learned friend said that it was implied assertion in my submissions that TMT only had assets in Switzerland. And I think I must have been unclear about this, because it's not the way that I put it. As I've said, it's not about where the assets are, it's about the domicile of the debtor. But if it matters, and I say it doesn't, then TMT's assets are strewn around in various jurisdictions, as we see from the asset disclosure, which is at S25, Supplemental Bundle, tab 25, page 201, is asset disclosure given by TMT, admittedly in 2024. I won't trawl through it all, but one can immediately see that there are various jurisdictions, including the UK, but also including Switzerland, the UAE, various trade receivables from companies, at least some of which appear to be incorporated in Singapore, being PTE limited companies. There's also in the bundle a placement memorandum closer to the relevant date in December 2022 at S/11/69, where TMT gives disclosures about its exposure to political risk, and on the second bottom paragraph on that page, it states that TMT operates and owns assets in a large number of geographic regions. So
I'm not sure that's the kind of reply point. We're looking for reply points to what.
Well, it was. My learned friend was saying that that TMT's assets were in England.
Well, they may or may not be in England. He showed us one document that showed some evidence of some monies being paid into an English bank account owned by TMT between February and August 2022. I've no idea whether you've got any assets, or TMT had any assets in England or China or America or the South Pole.
My lord, yes. Not sure there are any assets in the South Pole. I won't press that. My lord, in relation to those assets to which my learned friend refers, the specific ones that were drawn to your lordship's attention, those are the payments in the Trafigura litigation, to which Trafigura, of course, asserts proprietary claim. That is in the evidence at page.
Well, we can't determine the Trafigura claim.
No, quite. And that's, in a sense, that's the point that I wish to make. That what he can't really say is that he would have been that Sucden would have been in a better position from enforcing earlier against those monies when Trafigura has a proprietary claim to them. And this court's in no position to determine whether that is a good claim or whether those assets would have been available.
Well, he can't prove that factually, but he can say that that's his pleaded case, if that's his pleaded case.
Well, I accept that it's his case that because there were assets in England, that's where damage was suffered. Which I dispute for the reasons I've given. Now, the next point that my learned friend made was that the dolphin and pan-oceanic line of authority are not confined to cases involving an inducing breach of contract. I don't say that they're confined to a specific tort, and that's why I accepted that they could also, in principle, apply to a Marex tort, as in Lactamian shipping. The reason why I say those cases need to be confined is that they all involve a breach of duty that operates on the paying party rather than the enforcing one. My learned friend then referred to Article 4.3, but I think that was dealt with in an exchange with your lordships. So it may be that I don't need to go there.
You moved on rapidly.
Yes. I ought just to correct that I didn't say in my opening submissions that I anticipated the point, as my learned friend suggested, by saying that he wasn't entitled to make it. The point that I was making in my opening submissions is that's what I understood to be common ground, that it was only Article 4.1 relied upon. My Lord, in relation to necessary and proper party, my learned friend explained that he came within the will be served part of the gateway on the basis that it could have been served out of the jurisdiction under 6.332b, even if it was not. And as I understand it, the effect of this submission is that even if Mr. Gupta's application to set aside the extension order is successful, he would say it doesn't matter because we could have served them.
I'm wondering about whether it's that or this may be an alternative variant of it, but the hypothetical I put to Mr. Robinson, where you have an ability by one means or other to effect service on the anchor defendant, either without leave under 633 or with it under one of the English law contract gateway or whatever it might be, and you write to them or you write to solicitors saying please accept service in the jurisdiction, give us an address for service, and they do. Something that where it's an additional claim brought in the course of ongoing litigation, frankly, we expect solicitors on the record to do rather than avoid needless expense in effecting service overseas. Do you say in that scenario that the necessary or proper party gateway could not be relied upon if that was the anchor claim against the anchor defendant?
Well, my lord, I don't need to say that.
I'm just trying to test it because, of course,
Yes.
what happens here may not be a million miles away from where a party says, I've been served by this route, I could object to it, but there's no point because I'm going to right to be served by some other way. I'm not sure
Yes.
those situations are that distinct.
Well, that very distinction has been the subject of some cases, because one first has John Russell in 1912, where the House of Lords says that the requirements of service inure to the benefit of the additional defendant, not just the anchor. And then that case is qualified in the subsequent decision in the Benati, in the Court of Appeal, where, in fact, the Court of Appeal reaches very much the conclusion that your Lordship has formulated, that if the party, before the claim is issued, says, we see that you'll be able to service, so we'll accept service, then the John Russell principle doesn't apply. And that's usefully summarised in the decision of ID and LU by His Honour Judge Pelling QC, as His Excellency then was, in Authorities Bundle, tab 31, page 1079. And the conclusion, so it's at paragraph 38.
Yep.
So in the Bernati, the Court of Appeal confined the effect to John Russell. That's
Yeah.
the House of Lords.
We've
decision
read
saying.
that bit, yeah.
Yes, yeah. To cases where at the time the writ was issued, there was no one on whom the writ could be served, and only at a later stage did one of the defendants accept jurisdiction. A bit further down, just by letter F, in that case, the Court of Appeal considered that the rule didn't apply because before the writ had been issued, the first defendant, under the threat of arrest of a ship, had decided to accept service. And His Lordship expresses some doubt about that distinction. There's also an interesting quirk in that the Bernati is a decision made on a without notice appeal to the Court of Appeal, but was subsequently, by Mr. Justice Webster in the Alexandros, referred to there just by letter G, found to be binding nevertheless. But really the point about that principle, even if it's right, is that because the solicitors for the defendant right to say will accept service in the jurisdiction, that provides the very foundation for service in the jurisdiction. What it doesn't amount to is an anchor defendant waiving rights that they already have in a way that prejudices an additional defendant. Because even the narrow principle which survives from John Russell is that a waiver of rights taken by an anchor defendant should not prejudice the additional defendant. And so my learned friend was right to say that that's not this case, because in this case, TMT was served under Rule 6.11. It didn't take issue with that and served a defence, so it waived its right.
So if it had taken issue with it,
Yes.
and the response to it taking issue had been a 633 2B service of the claim format of the jurisdiction, then the necessary or proper party would not be able to challenge the existence of the gateway. But if it decides not to take the point in anticipation of that state of affairs, you say it then becomes impossible to join another party through the necessary or proper party gateway by reference to that anchor defendant.
Well, my lord, yes, and
It was simply a question to clarify.
I appreciate that one might think that that's artificial, but it's not artificial, and this is why. The House of Lords in John Russell explains that the service on the anchor defendant inures to the benefit of the additional defendant as well. A claimant is aware, should be taken to be aware of that at all times, because that's the law. Now, that means that the claimant can and should effect service validly at the outset, and even if TMT, the anchor defendant, doesn't pursue the objection to jurisdiction that it has based on the service that has been effected, then if the claimant wishes to establish the necessary and proper party gateway against an additional defendant, it's still incumbent on it for that purpose to effect service validly.
And if the anchor defendant does take the point and the judge hearing it says, this is a complete waste of time, I'm going to order, and orders of this kind are made, I'm going to order what has been done is sufficient for service or alternative service or whatever it may be. Is it still the case that the necessary or proper party gateway is not available off the back of claim against the anchor defendant served in that way?
Well, my lord, no, because in that case, there has been valid service of the
Through the alternative service.
through the order made by the court.
If we were to make an order deeming that what had been done on the anchor defendant was sufficient service, this point would go away.
Well, if your lordships were to find that the service pursuant to Rule 6.11 was valid, then I agree. That would be the end of the service issue. If your lordship is considering an order.
I mean, no one's asked us to make one, and I'm just trying to test
Yes.
the practical implications of this argument.
No, I'm doing my best to engage with it,
Yeah.
my lord. But
Certainly wasn't inviting Mr. Robinson to pop up now. But,
no. But the difference of principle in this case is that there's not some defective service that occurred back in 2023, which could be somehow deemed to be valid service. The service that was effective pursuant to Rule 6.11 is either valid or it's not.
I understand. That's very helpful. Thank you.
So, my lord, that's the service point. And then finally, there was a point made about 6.11 that provided one claim in the claim form can pass through 6.11, then that claim would survive even if there are other claims in the claim form which don't come within the rule.
I can understand why you say that. That's a very difficult argument.
I find that a little troubling, because, really for the reasons that my lord, the Master of the Rolls, gave, because then one ends up with claim forms with...
We will note that as your submission.
Yes, well, I can't improve on it, so I shan't try. My lord, my lady, unless I can be of assistance, those are Mr. Gupta's.
Thank you very much. Mr. Trotter. Mr. Robinson, I think formally you have the option to tell us what John Russell and Company and Kaiser Irvin and Company Limited, how this affects your case.
Yes,
You're not obliged to.
just very quickly. The point in that case is that there was no other mechanism by which the claim form could have been validly served. That's the key point of distinction. So
It was the good old days of concurrent writs.
yes, so the acceptance by the anchor to service was the only legitimate mechanism by which that party was going to be sued in this jurisdiction. Completely different in our case because of
Also, the rule in those days required, there was no will be served.
yes.
It was duly served within the jurisdiction.
Yeah, duly said. Good, thank you.
Thank you.
Well, thank you all for an interesting argument. We'll take time to consider our judgments. When we do hand down our judgments in draft, you will get a fairly short time to look at them. We'll try and give you notice that you're going to get a short time to look at them. And we want typographical corrections only, and you may use them only for the purpose of agreeing the order and costs. If, however, you need more time for agreeing costs and the order, I'm normally prepared to give an extra 7 days after hand down for you to do that. And if any disputes arise thereafter, we will deal with them in writing.
My lord, the hard copies of the Commercial Bank of Dubai case that you
Right, well, hand those up. These,
I have them in various different formats depending on what would be most convenient, hole punched or stapled.
hole punch, I guess. Hole punch, yes, 2 copies of each. And soft copies for my clerk, to my clerk, please.
Yes, we'll arrange that.
Lovely. Well, many thanks to all.